Oh, hey friends, it's Josh Yeager, walking in Santa Barbara with Dodger. Hi, Dodger. And thinking about trust and estates issues. Today I'd like to share with you the curious case of Halvard Heggstad, which is informative on a number of trust and estates administrative items. Number one, Halvard owned a piece of property by himself, not co-tenancy with his wife, not community property. And on his trust doc, he wrote the instructions of what's supposed to happen to his separate property and community property and his combined estate plan with his beautiful wife, Betty. I'm not sure that that's her name, but let's just pretend it is. And his instructions were, any of my separate property and community property goes into a trust for my boy Bert. Again, don't know if that's the name. And he noted on Exhibit A of the trust a piece of property at 100 Independence Road. That is the address of that property. And but old Halvard made a mistake. He never changed title of that property when he died, or before he died. He never changed the deed. The deed just said Mr. Heggstad's property, his sole and separate property. So he goes off and dies, and the property's never been moved into the trust, but the trust document is clear that Mr. Heggstad intended for that asset to be moved into the trust, as evidenced by Exhibit A, the recitation of what the trust held. So, what are we supposed to do? That's the big court case. The lawsuit between son, who had dad actually taken the right steps and transferred title of the property into the trust, then it would have been in the trust, clearly. The language of the trust, the dispositive terms, what happens at the end, would have been followed. The title would have been identified as Mr. Heggstad's separate property held by the Heggstad Trust. But he never did that. So Mom argues, this is outside the trust. He never did the things that you're supposed to do. We have to probate that asset, and the result of probating that asset is I, the surviving spouse, get it. Son, Glenn, says, oh, wait just a minute. It's clear what Paul wanted to do. He wanted to transfer that asset into the trust, and he wanted me to get that asset following his death, as evidenced by Schedule A. So the judge scratches his head and thinks, what should we do here? And the conclusion is a really, really important case in California. It leads to what is now called the Heggstad petition. And this is where a settlor, dad, identifies that he has some intention of transferring a property into the trust, the Schedule A of the trust document, for example, or the words within the trust document. I want my son to get the land at 100 Independence Lane, or on the schedule, like I said, that property is noted as a trust asset. And then dad fumbles, doesn't actually fund the trust the way he has intended to fund it, and he dies. And the new rule is, well, you got to start the probate process. You have to go to the judge and say, Judge, hey, look, there was this asset. It was intended to be in the trust. We can see that that the settlor intended it to be in the trust. Never got there for one reason or another. We don't know why. Dad was lazy, misunderstanding. Who knows? Never got there. But we want you to look at the facts and move that asset into the trust and truncate the probate process and do what the trust says, or direct that the trust instructions be binding on everyone, and that we don't have to go through probate with this thing. And the judge said, yeah, that's the new approach. That's the Heggstad petition. My partner Ryan is dealing with one of these right now, where Schedule A says the JP Morgan account is owned by the trust, and settlor never got around to telling his JP Morgan guy that he had a trust and that he needed to change title. And so Ryan is making an argument to the judge that, yeah, the asset is not titled in the trust. It should have been titled in the trust. and the exhibit attached to the trust document clearly demonstrates settlor's intentions. So that's a way to untie the Gordian knot. If the settlor has messed up and not actually acted on their intentions, hasn't actually followed through with the documentation they should do, either with real property, change in deeds, or with liquid assets, change in title, or assigning assets to the trust, the aforementioned Heggstad petition is a way of getting it in the trust. Thus ends the mini lecture during our walk and talk. Ciao, folks.